Legal disclaimer. The information presented in this video series, including all spoken narration, on-screen text, and linked resources, is strictly for educational and informational purposes only. This content does not, under any circumstances, constitute legal advice, professional career counseling, or a formal recommendation to take specific action in your personal workplace disputes. I am not an attorney, I am not a labor union representative, and I am not a certified human resources consultant. Employment laws in the United States are subject to a complex, constantly shifting framework of federal statutes, state-specific regulations, and local municipal ordinances that vary significantly depending on your geographic location. What is true for a worker in Montana is fundamentally different from the legal reality for a worker in Florida. Furthermore, specific case law precedents can alter the interpretation of these statutes at any time. If you are currently facing a hostile work environment, wrongful termination, discrimination, harassment, or wage theft, you must conduct your own due diligence. We strongly recommend consulting with a qualified labor attorney or contacting the appropriate government agencies directly to discuss the specifics of your individual situation. Reliance on any information provided in this video is done solely at your own risk. By continuing to watch, you acknowledge that this content is a high-level guide to understanding the landscape of U.S. resources and is not a substitute for professional legal counsel. Consider this scenario. It is 4:45 p.m. on a Friday. You have worked at your company for 5 years. You have never had a negative performance review. In fact, you were the top performer in your department last quarter. You are called into a small windowless conference room. Your manager is there, looking at the floor. A representative from HR, someone you have spoken to maybe twice in your life, is sitting across from you with a manila folder. They slide a single sheet of paper across the table. They tell you that your position is being eliminated, effective immediately. Or perhaps they tell you that your services are simply no longer needed. When you ask why, when you demand to know what you did wrong, they give you a vague non-answer. It's just not a good fit anymore. You are escorted to your desk to collect your keys and your coat, and then you are walked out of the building. You are standing in the parking lot, holding a cardboard box, wondering if what just happened was even legal. The terrifying reality for the vast majority of the American workforce is that, yes, in many cases that scenario is perfectly legal. But here is the controversial truth that most corporations rely on you not knowing. While the broad shield of at-will employment allows companies to fire you for almost any reason, or no reason at all, it does not allow them to fire you for illegal reasons. And the line between a standard firing and an illegal termination is often buried in a mountain of paperwork, subtle retaliations, and protected activities that you didn't even know you were engaging in. Did you know that in the United States, wage theft, employers not paying workers what they are legally owed, accounts for more money lost annually than all robberies, burglaries, and motor vehicle thefts combined? We are talking about billions of dollars extracted from the pockets of employees, not through gunpoint, but through misclassified overtime, off-the-clock work requirements, and illegal deductions. Yet, despite the scale of this issue, the average American worker is woefully undereducated on the specific mechanisms available to fight back. We are taught how to write a resume. We are taught how to interview. We are taught how to climb the corporate ladder. But we are almost never taught how to navigate the bureaucratic labyrinth of the Equal Employment Opportunity Commission, the Department of Labor, or the National Labor Relations Board when the latter is pulled out from under us. This creates a dangerous asymmetry of power. Your employer has a legal department. They have retained counsel. They have HR policies written by experts designed to minimize their liability. You have Google search results that give you contradictory advice and forums filled with anecdotes that may not apply to your state. When you are in the heat of a workplace crisis, whether it is sexual harassment, unsafe working conditions, or sudden unemployment, you are in a state of high emotional distress. That is exactly the wrong time to try to teach yourself the nuances of administrative law. The system is designed to be difficult. It is designed to be discouraging. The paperwork is dense, the deadlines are strict, and the burden of proof is almost entirely on you. If you miss a filing deadline by one day, you could lose your right to sue. If you sign a severance agreement without understanding the fine print, you could be waiving your right to speak out about illegal activities you witnessed. This brings us to the purpose of this deep dive masterclass. This is not a 10-minute summary video. This is not a collection of life hacks for the office. This is a comprehensive, granular, step-by-step educational resource designed to level the playing field. Over the course of this 10-part series, We are going to dismantle the complexities of the U.S. labor resource system. We are going to move beyond the surface-level advice of just hire a lawyer, because we know that lawyers are expensive and many workers cannot afford a retainer. And instead, we are going to focus on the federal and state agencies that are funded by your tax dollars to protect you. Our promise to you is clarity in the face of chaos. We are going to dissect the anatomy of the Equal Employment Opportunity Commission, EEOC. We will not just tell you what it is, we will walk you through the charge of discrimination timeline. We will explain what a right to sue letter is, why you need one, and why receiving one does not necessarily mean you have a winning case. We will look at the Department of Labor, DOL, and specifically the Wage and Hour Division. We will explain how to audit your own pay stubs to detect if you are being cheated out of overtime pay under the Fair Labor Standards Act. We will explore the Occupational Safety and Health Administration, OSHA, delving into your right to refuse dangerous work and the specific protections against retaliation for whistleblowers. Furthermore, we will tackle the often misunderstood National Labor Relations Board, NLRB. There is a pervasive myth that the NLRB only matters if you are in a union. That is historically and factually incorrect. We will show you how the National Labor Relations Act protects your right to discuss your wages and working conditions with your coworkers, regardless of whether a union exists in your workplace. We will discuss the specific language you should use when documenting incidents with HR to ensure you are creating a paper trail that holds up in a legal context. We are going to look at historical trends in employment litigation to understand what makes a case viable and what causes cases to fall apart. This series is designed to function as a toolkit. By the end of these 10 parts, you will not be a lawyer, but you will be an informed, empowered participant in the economy. You will understand the difference between unfair treatment and illegal discrimination. You will know where to look to find your state-specific labor board. You will understand the critical importance of documentation, emails, memos, performance reviews, and how to organize them before you ever step foot in a lawyer's office or file a government complaint. The workplace is where we spend 1/3 of our lives. It determines our financial security, our healthcare access, and often our sense of self-worth. When that environment turns toxic or illegal, the impact is devastating. You do not have to navigate that darkness alone, and you do not have to navigate it blindly. We are going to turn the lights on. We are going to look at the machinery of the system. We are going to read the fine print together. This is part 1 of Navigating Workplace Issues, a guide to U.S. resources. Let's begin. To understand the machinery of the U.S. labor resource system, we must first clear the rubble of the single biggest misconception that destroys potential legal cases before they even begin. That misconception is the definition of at-will employment. If you are working in the United States, outside of Montana, and absent a specific union collective bargaining agreement or a high-level executive contract, you are likely an at-will employee. This is the bedrock upon which the American labor market is built. In practical terms, at-will employment means your employer can terminate your employment at any time, for any reason, or for no reason at all. They can fire you because they do not like the color of your shoes. They can fire you because the CEO woke up in a bad mood. They can fire you because they simply want to cut costs and you happen to be the name at the top of the spreadsheet. Fairness is not a legal requirement in the American workplace. Being a bad boss is not illegal. Being incompetent at management is not illegal. Creating a stressful, chaotic, or even miserable work environment is largely not illegal. However, and this is the critical pivot point where your power lies, the doctrine of at-will employment is not absolute. It has very specific, very sharp boundaries known as statutory exceptions. While they can fire you for no reason, they cannot fire you for an illegal reason. This distinction sounds simple, but in the real world, it is incredibly messy. Illegal reasons typically fall into 3 primary buckets: discrimination against a protected class, retaliation for engaging in a protected activity, or violation of public policy. Let's look at a case study to see how this plays out in reality. Imagine 2 employees, Sarah and Mike. Both work in sales at the same mid-sized tech company. Both have missed their quota for 2 consecutive months. The company decides to fire Sarah. Sarah is 55 years old and the only woman on her team. Mike is 28. On paper, the company says Sarah was fired for performance issues. Under at-will employment, firing someone for missing quotas is perfectly legal. If Sarah walks away, accepts the severance, and moves on, that is the end of the story. But let's look deeper. Imagine that 3 months prior, Sarah's manager made comments about her energy levels, not keeping up with the young, hungry culture of the team. Imagine that Sarah was excluded from client dinners that Mike was invited to. If Sarah attempts to sue for age or gender discrimination, or files a complaint with the Equal Employment Opportunity Commission, EEOC, the company will point to the missed quotas. They will say, "This isn't about age, look at the numbers." This brings us to the single most important skill you will learn in this masterclass: the art of the contemporary paper trail. In the eyes of the law and government agencies, if it is not written down, it effectively did not happen. Most employees wait until they are fired to start gathering evidence. By then it is often too late. You have been locked out of your email, you have been escorted from the building, and your access to the servers has been revoked. To navigate workplace issues, you must adopt the mindset of a forensic accountant regarding your own career history. You need to generate what legal professionals call contemporaneous documentation. This means documenting events when they happen, not trying to remember them 6 months later. Memory is fallible. A time-stamped email is evidence. Let's go back to Sarah. In a scenario where she navigates this correctly, she does not just let the manager's comment about energy levels slide. She returns to her desk and sends an email to her manager. She uses a technique we call the innocent clarification. She writes, "Hi, I just wanted to recap our meeting to make sure I'm aligned on the goals. You mentioned needing higher energy levels to match the younger culture of the team. Could you clarify what specific metrics or KPIs you are referring to so I can adjust?" Notice what she did there. She did not accuse him of discrimination. She did not get angry. She simply created a time-stamped record that the comment was made. If the manager replies and doubles down, she has direct evidence. If the manager replies and denies it, she has still created a record that puts the company on notice. Even if he does not reply, the sent email serves as a record of her understanding of the meeting. This extends to performance reviews. If you receive a negative performance review that you believe is factually incorrect or biased, you must not just sign it and walk away. Most companies allow for an employee comment section or a formal rebuttal. You should professionally, unemotionally, and factually refute the incorrect points with data. The review states, "I missed the project deadline on the 12th. Please see the attached email confirmation where I submitted the deliverables on the 10th. By doing this, you are effectively poisoning the well for the company's legal defense. You are making it significantly harder for them to claim later that you were fired solely for incompetence, because the record shows you contested the inaccuracies in real time. Let's analyze another imagine-if scenario involving retaliation, which is arguably the most dangerous trap for employers and the strongest claim for employees. Imagine you work in a warehouse. You notice that the fire exits are routinely blocked by stacked pallets, a clear violation of Occupational Safety and Health Administration, OSHA standards. You mention this to your supervisor verbally. He shrugs it off. 2 weeks later, you are transferred to the night shift, a shift you specifically said you could not work due to childcare. You quit because you cannot work the hours. This is called constructive discharge, when a workplace becomes so intolerable that a reasonable person would feel compelled to quit. If you claim retaliation, the company will say the shift change was a business necessity. Without documentation, it is your word against theirs. However, imagine if, after the verbal conversation with the supervisor, you sent an email to the safety officer or HR, or even a text message to your supervisor saying, "I am concerned that the pallets blocking exit B are a safety hazard. I am reporting this to ensure we are compliant." Now, the timeline looks suspicious to any investigator. Event A: you engaged in a protected activity, reporting a safety violation. Event B: adverse employment action taken against you, transfer to an impossible shift. The proximity in time between these two events, supported by your documentation, creates a causal link. Retaliation claims often succeed, even when the original underlying claim, the safety issue or the discrimination, fails. The law punishes the cover-up and the punishment often more severely than the crime. But here is a critical warning regarding documentation: data privacy and trade secrets. In your zeal to document, do not violate your company's non-disclosure agreements, NDAs, or data protection policies. Forwarding confidential client lists or proprietary code to your personal Gmail to protect yourself can get you countersued for theft of trade secrets. It can destroy your credibility and give the employer a legitimate, legal reason to fire you that supersedes your discrimination claim. The safe way to document: keep a personal journal. Use a bound notebook, not a spiral one where pages can be torn out unnoticed, but a bound composition book. Write the date, the time, who was present, and a factual summary of what was said. 10:15 a.m., meeting with John Doe. John stated that women don't have the stomach for this client. I objected, stating my sales record. Courts have historically accepted contemporaneous personal notes as credible evidence because they were written at the time of the event. Alternatively, send emails to yourself from your personal account to your personal account, describing the events of the day. This creates a digital timestamp that is not on the company servers. So, you have identified that your issue might be more than just unfair, it might be illegal. You have started your documentation journal. You have your innocent clarification emails saved. You are building a file. But a file sitting in your desk drawer does not solve the problem. You need to know where to send it. You need to know which government lever to pull. Do you go to the State Labor Board, the Federal EEOC, the Department of Labor, or do you hire a private attorney immediately? The answer depends entirely on the specific nature of your problem. If it is unpaid overtime, the EEOC cannot help you. If it is sexual harassment, the Department of Labor is the wrong door. And if you knock on the wrong door, the statute of limitations, the ticking clock that determines how long you have to file a claim, keeps running. In some cases, you have as few as 180 days from the incident to file. If you waste 90 of them waiting for a response from the wrong agency, you might forfeit your justice. In the next part of this masterclass, we are going to walk through the doors of the Equal Employment Opportunity Commission. We are going to explain the critical mandatory process known as exhaustion of administrative remedies. We will explain why you literally cannot sue your employer for discrimination in federal court until you have completed this specific bureaucratic step, and we will show you exactly what that process looks like from the intake questionnaire to the right to sue letter. You have the evidence. Now let's see how to weaponize it. This is part 2. Stick around. Stop. Put down the lawsuit. Do not drive to the courthouse. Do not pay a filing fee. If you walk into a federal court tomorrow morning and attempt to sue your employer for discrimination based on race, religion, gender, disability, or age, the judge will not just look at your evidence. They will look for your permission slip. And when you do not have it, they will dismiss your case immediately. It does not matter if you have video evidence. It does not matter if you have a signed confession. Without the specific authorization from the federal government, you are legally barred from entering the courtroom. This is the concept of exhaustion of administrative remedies, and it is the single most critical procedural hurdle in American employment law. The system is designed with a gatekeeper. That gatekeeper is the Equal Employment Opportunity Commission, or the EEOC. Congress created this agency to act as a filter. The logic is that if every workplace dispute went straight to federal litigation, the court system would collapse under the weight of the paperwork. So, before you can sue, you must first give the EEOC a chance to resolve the dispute. Let's walk through the doors of this agency and break down exactly how to navigate it, because the process is filled with traps that can time-bar your claim forever. The first trap is the calendar. The statute of limitations in employment law is shockingly short. In the world of personal injury, you might have years to sue after a car accident. In the world of employment discrimination, the clock starts ticking the moment the discriminatory act happens, not the moment you realize it was illegal, but the moment it happened. Generally, you have 180 days to file a charge with the EEOC. That is less than 6 months. If you spend 5 months hoping things get better, or 3 months looking for a new lawyer, you are dangerously close to losing your rights. However, there is a complexity here known as the deferral process. If you live in a state or locality that has its own anti-discrimination agency, often called a Fair Employment Practices Agency (FEPA), the filing deadline is usually extended to 300 days. For example, California has the Civil Rights Department. New York has the Division of Human Rights. Because these states have their own enforcement mechanisms, the federal government gives you more time. But if you live in a state without such an agency, you are stuck with the strict 180-day window. Do not assume you have 300 days. Assume you have 180. The safest strategy is to act immediately. So, how do you actually file? You do not just send an email. You must navigate the EEOC public portal. This begins with an inquiry, often involving an intake questionnaire. Here is the second major trap. Submitting an inquiry is not the same as filing a formal charge of discrimination. Many workers fill out the questionnaire, hit submit, and think they are done. They wait for months, thinking the investigation has started. Meanwhile, the 180-day clock runs out. The inquiry is just a request for an interview. You must formally sign and verify a charge of discrimination, EEOC Form 5. for the legal process to technically begin. Until that document is signed, usually electronically or in the presence of an EEOC investigator, you have not stopped the clock. Let's look at a case study to see this mechanism in motion. Imagine David. David is a 62-year-old software engineer. His new manager, who is 30, starts making comments about David being old school and needing to refresh the team's image. David is put on a performance improvement plan (PIP) with impossible goals and eventually fired. David believes this is age discrimination under the ADEA, Age Discrimination in Employment Act. David logs into the EEOC portal and schedules an intake interview. This interview is crucial. The investigator is neutral. They are not David's lawyer. They are a fact finder. David presents his contemporaneous documentation, the notes from part 2 of this series, showing the age-related comments. The investigator drafts the charge of discrimination. David signs it. At this moment, the charge is served to the employer. This is often the first time the company realizes David is serious. The company's legal team receives a notification that they are under federal investigation. This triggers a frantic internal process. The company must preserve all documents. Deleting emails about David now becomes a federal crime called spoliation of evidence. The EEOC will often offer both parties a choice. Mediation. If you are offered mediation, you should strongly consider it. Mediation is a voluntary, confidential process where a neutral mediator helps David and his former employer reach a settlement. Why would a company agree to this? Because it is cheap and it is quiet. If the case goes to court, the allegations become public record. Shareholders see them. Future employees see them. In mediation, the company can agree to pay David a lump sum, say 6 months of severance, in exchange for him dropping the charge and signing a non-disclosure agreement. For many people, this is the best outcome. Money in your pocket quickly, without the trauma of a 3-year court battle. If mediation is refused or fails, the case moves to the investigation phase. The employer is required to submit a respondent's position statement. This is their version of the story. They will say David was not fired for his age. He was fired for performance. They will attach the PIP. David will then be given a chance to respond to their lies. This is where your paper trail becomes your weapon. You can dismantle their statement point by point. Now, we must manage your expectations about the outcome. The investigation can take 10 months, sometimes longer. At the end, the EEOC will issue a determination. There are 2 main outcomes. Outcome A. Reasonable cause. The EEOC believes discrimination likely occurred. They may try to settle the case for you, or in very rare, high-impact cases, their own lawyers will sue the company on your behalf. This happens in less than 2% of cases. Outcome B. Dismissal and notice of rights. You will receive a letter saying the EEOC was unable to conclude that the information obtained establishes violations of the statutes. Receiving this dismissal letter feels like a punch in the gut. It feels like the government is saying, "We don't believe you." But that is not necessarily what it means. It often simply means, "We are underfunded, understaffed, and we do not have the resources to pursue this specific case further." Crucially, this dismissal letter is the golden ticket you have been waiting for. It is your right to sue letter. Once you have this piece of paper in your hand, the gate is open. You have exactly 90 days, a strict non-negotiable deadline, to file a lawsuit in federal or state court. If you file on day 91, your case is dead. This letter allows you to hire a private attorney and proceed to litigation, where you can subpoena witnesses and demand documents that the EEOC might not have bothered to ask for. The EEOC path is primarily for discrimination, harassment, and retaliation related to your identity, who you are. But what if your issue isn't about your age, race, or gender? What if the issue is purely mathematical? What if you worked 50 hours last week, but your paycheck only shows 40? What if your boss classifies you as an independent contractor, but treats you like an employee to avoid paying taxes? The EEOC has no power there. For issues of money, time, and theft of wages, there is a completely different federal beast you must summon. It is an agency with the power to audit company books, freeze assets, and demand back pay for thousands of workers at once without you ever having to hire a lawyer. This is the realm of the Department of Labor and the Fair Labor Standards Act. In the next part, we are going to expose the epidemic of wage theft. We will explain the salaried exempt trap that millions of Americans fall into, thinking they aren't entitled to overtime when they actually are. We will show you how to audit your own pay stub like a forensic accountant, and who to call when the numbers don't add up. The money you are owed is likely sitting in your employer's bank account. Let's go get it. This is part 3. If you walked out to your driveway tomorrow morning and found your car was gone, you would call the police immediately. You would file a report. You would check your insurance. You would be outraged. Yet, every single day in the United States, employers reach into the pockets of their workers and take billions of dollars, not by smashing a window, but by manipulating a spreadsheet. This is wage theft. It is the single most common form of property crime in America, costing workers an estimated $50 billion a year, far more than all bank robberies, gas station holdups, and convenience store heists combined. And the most insidious part? Most victims do not even know they have been robbed. They think they are just working hard. They think checking email at 9 p.m. is just being a team player. They think that because they receive a fixed salary, they are not entitled to another dime. In many cases, they are factually legally wrong. Welcome to the jurisdiction of the Department of Labor DOL, and its enforcer, the Wage and Hour Division, WHD. Unlike the EEOC, which deals with discrimination, the DOL deals with the hard math of the Fair Labor Standards Act, FLSA. The FLSA is the federal law that establishes minimum wage, overtime pay, record-keeping, and youth employment standards. If you work in the private sector, federal, state, or local government, this law likely covers you. Let's dismantle the biggest lie in the American workplace: the salaried myth. There is a pervasive belief that if you are paid a salary, a flat amount per year, you are automatically ineligible for overtime pay. Employers love this myth. They rely on it. But under the FLSA, paying someone a salary does not automatically make them exempt from overtime. To be truly exempt, and therefore not owed time and a half for every hour worked over 40, you must generally pass 3 specific tests: the salary basis test, the salary level test, and most importantly, the duties test. Let's look at a case study to see how companies weaponize titles to fail the duties test. Imagine Jessica. Jessica works at a fast food franchise or a retail coffee shop. Her title is Assistant Manager. She is paid a salary of $45,000 a year. Because she is a manager, her boss tells her she is exempt from overtime. She works 60 hours a week. If you do the math, her hourly rate drops significantly, but she gets no extra pay. Here is where the investigation begins. Under the executive exemption of the FLSA, a job title means nothing. The law looks at what Jessica actually does. Does she hire and fire? Does she set schedules? Does she have weight and personnel decisions? Or does she spend 90% of her time making coffee, sweeping floors, and running the cash register, the exact same work as the hourly employees? If her primary duty is manual labor or customer service, and she has no real authority, she is likely misclassified. She is likely a non-exempt employee disguised as a manager. That means the company owes her back pay for every single hour over 40 she worked in the last 2, or sometimes 3 years. That $45,000 salary was just a down payment on what she is actually owed. This misclassification happens in white-collar jobs too. The administrative exemption is often abused for administrative assistants or help desk IT workers who are told they are exempt, but do not actually exercise discretion and independent judgment on matters of significance. If you are just following a strict manual and have no authority to deviate, you might be entitled to overtime regardless of your salary. Now let's talk about off-the-clock work. This is the silent killer of the modern workday. The smartphone has dissolved the boundary between work and home, but the law has not changed. If you are a non-exempt employee, and your boss texts you at 8:30 p.m. asking for a file, and you spend 15 minutes finding it and sending it, that is compensable work time. If you are required to put on specific safety gear or a uniform at the job site before you clock in, that is often compensable work time. Amazon, strictly as a historical example, has faced massive litigation regarding security screenings. Whether employees should be paid for the time they spend waiting to be searched before leaving the warehouse. While Supreme Court rulings on specific post-shift activities have favored employers in some contexts, the general principle remains. If you are doing work that benefits the employer, you must be paid. If you are required to be at a specific place at a specific time, the clock is ticking. Consider the gig economy trap, independent contractor misclassification. This is the frontier of wage theft. Companies like to classify workers as 1099 independent contractors rather than W-2 employees. Why? Because independent contractors do not get minimum wage, they do not get overtime, and the company does not pay payroll taxes or unemployment insurance for them. Here is the test. Control. If you are truly an independent contractor, you should be able to set your own hours, use your own tools, and work for other clients. If your client tells you when to arrive, when to leave, provides your laptop, gives you a uniform, and prohibits you from working for their competitors, the Department of Labor may look at that relationship and say, this is an employment relationship. If you have been misclassified as a contractor, you may be missing out on thousands of dollars in benefits and overtime protections. So you have audited your pay stubs. You realized your assistant manager title is a sham. You realized you have been working 50 hours a week for 40 hours of pay. What do? Unlike the EEOC, where you effectively need a right to sue letter to move forward, the FLSA allows for a private right of action, meaning you can sue directly. However, the Department of Labor's Wage and Hour Division acts as a powerful alternative. You can file a confidential complaint with the WHD. You do not need a lawyer to do this. You do not need to pay a fee. When the WHD investigates, they do not just look at your paycheck. They often trigger a wall-to-wall audit. They come in and demand to see the payroll records for everyone. If they find violations, they can supervise the payment of back wages. And here is the hammer that the FLSA gives you: liquidated damages. Under the law, if an employer fails to pay you minimum wage or overtime, they are often liable not just for the money they owe you, but for an equal amount in liquidated damages. This effectively means double damages. If they stole $5,000 from you, they might owe you $10,000, plus your attorney's fees if you went the private lawsuit route. This provision exists specifically to punish employers and deter wage theft. Furthermore, the look-back period is crucial. Generally, you can recover wages for the last 2 years. But if you can prove the violation was willful, meaning the employer knew they were breaking the law or showed reckless disregard for whether they were prohibited from doing so, the statute of limitations extends to 3 years. That one extra year can mean thousands of dollars in your pocket. But money is only one part of the workplace equation. You can be paid fairly and still be in mortal danger. You can have a perfect paycheck in a workspace filled with asbestos, exposed wiring, or machinery that lacks safety guards. While the Department of Labor protects your wallet, there is another agency born from the blood and struggle of the Industrial Revolution, designed to protect your life. This agency has the power to shut down construction sites, levy massive fines, and inspect factories without a warrant. Yet, many workers are terrified to call them because they fear they will be fired for being a snitch. In the next part, we are going to dismantle the fear surrounding OSHA, the Occupational Safety and Health Administration. We will explain your absolute right to refuse dangerous work without being fired. We will walk you through the specifics of an OSHA complaint and tell the story of how one whistleblower's phone call saved an entire shift from a catastrophic failure. Your life is worth more than your deadline. This is part 4. There is a haunting statistic that sits in the archives of the Department of Labor. On average, 14 American workers go to work and never come home every single day. They die from falls, from equipment malfunctions, from exposure to toxic substances, and from explosions. These are not just numbers, they are empty seats at dinner tables. And in almost every single one of these cases, someone knew there was a problem before the tragedy occurred. Someone saw the frayed wire. Someone saw the unstable scaffolding. Someone smelled the gas. But they remained silent because they were afraid of losing their paycheck. This silence is what the Occupational Safety and Health Administration, or OSHA, was designed to break. But there is a dangerous misconception that OSHA only matters if you wear a hard hat or work on an oil rig. This is false. OSHA's jurisdiction covers almost every private sector employer in the 50 states. Whether you work in a high-rise corporate office with poor ventilation, a hospital handling infectious waste, or a warehouse with precarious shelving, you are protected by the Occupational Safety and Health Act of 1970. At the core of this act is a powerful legal weapon, known as the General Duty Clause. While OSHA has thousands of specific regulations, telling employers exactly how high a railing must be or what kind of mask fits a specific chemical, regulators cannot predict every possible way a workplace can kill you. The General Duty Clause fills that gap. It mandates that every employer must provide a place of employment which is free from recognized hazards that are causing or are likely to cause death or serious physical harm. This means that even if there isn't a specific rule in the book about the specific weird machine or unique situation you are facing, if your boss knows it is dangerous and does nothing, they are breaking the law. But let's address the most extreme high-stakes scenario you might face: the right to refuse dangerous work. This is the nuclear option of employment law. It is the only time the law explicitly empowers you to say no to a direct order and legally protects your job, but only if you follow a very specific, strict set of steps. If you skip a step, you can be fired for insubordination, and the law will not save you. Let's walk through a life or death case study. Imagine Marcus. Marcus works at a recycling facility. One day, the conveyor belt jams. His supervisor hands him a crowbar and tells him to climb inside the hopper to clear the jam. However, the machine is not locked out, meaning the power is still on. If the jam clears while Marcus is inside, the machine will restart and he will be crushed. Marcus is terrified. He knows this is a death trap, but the supervisor says, "Do it or clock out for good." To legally refuse this work and be protected, Marcus must meet 4 conditions simultaneously. Reasonable belief. Marcus must truly believe that an imminent danger exists that could cause death or serious physical harm. It cannot just be unsafe, it must be immediately dangerous. No time for OSHA. The urgency must be so great that there isn't time to call an inspector to drive to the site before the work needs to be done. Employer refusal. Marcus must ask the supervisor to fix the danger. Please turn off the power and lock it out first, and the supervisor must refuse. No reasonable alternative. There is no other way to do the job safely. If Marcus meets all 4, he can refuse. But he shouldn't just storm off to his car. He should state clearly, "I am refusing this specific task because it puts my life in imminent danger. I am willing to perform other work until this is fixed." He should stay at the worksite unless ordered to leave. This distinction, willingness to do other work, is what separates a protected refusal from a wildcat strike or job abandonment in the eyes of an investigator. Now let's talk about what happens after the dust settles. Retaliation. You filed a complaint about mold in the office. You reported the blocked fire exits. 2 weeks later, your hours are cut, or you are moved to a worse location. This is illegal retaliation under Section 11C of the OSH Act. But here is the trap that ruins thousands of lives. The 30-day deadline. We mentioned earlier that the EEOC gives you 180 days to file a discrimination claim. The Department of Labor gives you 2 years for wage theft. OSHA gives you 30 days. If you are fired or retaliated against for raising a safety concern, you have exactly 30 days from the moment you learn of the retaliation to file a whistleblower complaint with OSHA. If you wait 31 days because you were giving the company a chance to make it right, or because you were grieving the loss of your job, your case is administratively dead. You cannot sue. You cannot appeal. The timeline is unforgiving. This is why, if you are ever fired after raising a safety concern, your very first phone call should not be to your mom, or your spouse, or even a lawyer. It should be to OSHA to lodge a retaliation complaint. You can always withdraw it later if it turns out to be a misunderstanding, but you can never file it late. So, how do you file a standard safety complaint before things get to the firing stage? You have options, and anonymity is your best friend. When you file a complaint via the OSHA website or phone hotline, you have the right to request that your name be withheld from your employer. OSHA takes this seriously. When the inspector shows up at your workplace, they will simply say, "We received a complaint about X," without revealing who sent it. However, you need to be strategic. If you are the only person who works on the specific machine you are complaining about, the anonymity won't protect your identity. Your boss will figure it out. In small teams, sometimes the best protection is safety in numbers. If 3 of you sign the complaint, it becomes much harder for the employer to target a single scapegoat without making it look like obvious retaliation. The inspection process itself is a powerful tool. When an OSHA compliance officer arrives, they have the right to interview employees privately. This is your moment of truth. You have the right to speak to the inspector without your boss hovering over your shoulder. You can tell them about the near misses, the broken alarms that were ignored, and the training sessions that were faked. These interviews are confidential. The inspector uses them to build a case for citations and fines. And while OSHA fines can sometimes feel like a slap on the wrist to a billion-dollar corporation, the willful violation tag is what companies fear. If a company is found to have willfully violated safety standards and a worker dies, that opens the door to criminal prosecution. Actual prison time for executives. Though this is historically rare, the threat alone changes behavior. We have covered your identity, EEOC, your money, DOL, and your physical safety, OSHA. But there is a 4th pillar of power in the American workplace that is perhaps the most potent and the most brutally suppressed. It is the power of the collective. There is a myth that you only have rights to organize or protest, If you are a member of a formal labor union, you might think, I work in a tech startup, or I work in a coffee shop, we don't have a union, so I can't band together with my coworkers to demand better treatment. That is a lie. The National Labor Relations Act, NLRA, protects your right to engage in protected concerted activity, regardless of whether a union exists or not. This means you have a federally protected right to discuss your wages with your coworkers. You have a right to circulate a petition about bad management. You have a right to refuse to sign illegal policies. In the next part, we are going to dive into the National Labor Relations Board, NLRB. We are going to explain why your employee handbook might actually be illegal. We will discuss the water cooler rule and how discussing your salary is not just tacky. It is a federally protected civil right that your boss cannot punish you for. We are going to teach you how to spot an unfair labor practice and how to fight back when management tries to silence the group. The power of one is strong. The power of many is unstoppable. This is part 5. Here is the single most pervasive lie in corporate America. Discussing your salary with your coworkers is unprofessional, against company policy, and grounds for termination. You have probably heard this in an orientation meeting. You may have seen it written in a handbook. You may have even signed a document agreeing to keep your compensation confidential. I am here to tell you that if you work in the private sector in the United States, and you are not a supervisor, that rule is likely illegal. It is a violation of federal law. And the piece of paper you signed agreeing to it? In the eyes of the National Labor Relations Board, NLRB, it is not worth the ink it is printed on. Welcome to the hidden power of the National Labor Relations Act, NLRA. Most Americans believe the NLRB only exists to referee disputes between giant unions and giant corporations. They think, I don't pay union dues, so this doesn't apply to me. This is a catastrophic misunderstanding of your rights. Section 7 of the NLRA grants employees the right to engage in protected concerted activity for the purpose of collective bargaining or other mutual aid or protection. Let's decode that legal jargon. Concerted activity simply means 2 or more employees acting together to improve their working conditions. It can also be one employee acting on the authority of others, or one employee trying to induce group action. Protected means your employer cannot fire you, demote you, or punish you for doing it. Let's apply this to the salary secrecy myth. Imagine Alex. Alex finds out that a new hire, who has less experience, was hired at a salary $10,000 higher than his. Alex goes to lunch with 2 coworkers, Sarah and Ben. He tells them, I think we are being underpaid compared to the new guys. How much are you making? Sarah says she makes $50,000. Ben says he makes $52,000. A manager overhears this conversation. He calls them into his office and issues a written warning for creating a hostile work environment and breaching confidentiality. Under federal law, that manager just committed an unfair labor practice, ULP. By discussing their wages, Alex, Sarah, and Ben were gathering information to determine if they were being treated fairly. This is the very definition of mutual aid. The NLRB has consistently ruled that pay secrecy policies are unlawful because they prevent employees from organizing. If you cannot discuss what you make, you cannot know if you need a union or a collective raise. This protection extends far beyond money. It covers discussions about safety conditions, scheduling policies, abusive management styles, and even the temperature of the office. If you and a coworker approach your boss together to complain that the AC is broken and it is too hot to work, that is protected concerted activity. If the boss fires you for complaining, they have broken the law. However, there is a dangerous trap here. The personal gripe rule. You must understand the distinction between concerted activity and complaining. If you walk into your boss's office alone and say, I hate this job, I want a raise, that is a personal gripe. It is not concerted, it's just you. And it is not necessarily for mutual aid. You can generally be fired for that. But if you say, my team is overwhelmed and we need to discuss overtime pay, you are now speaking on behalf of the group. The we saves you, thy sinks you. Now let's move to the digital battlefield, social media. This is where thousands of workers get fired every year, and only a fraction realize they had a legal defense. Can you be fired for posting about your job on Facebook or Twitter? The answer is a complex yes, but if you go on Facebook and write, my boss Karen is a total idiot and her breath smells, you will likely be fired. That is personal harassment and disparagement. The NLRB will not protect you. But imagine this scenario. You and your coworkers have been forced to work late without notice for 3 days straight. You go home and write a status update. Management is forcing the whole team to stay until 9 p.m. again without overtime pay. We are all exhausted and this is unsafe. Who else is dealing with this? This post is different. It addresses a term and condition of employment, hours and overtime. It seeks to initiate a discussion with coworkers. Who else is dealing with this? It is not just a personal insult. It is a critique of labor practices. The NLRB has historically viewed this kind of virtual water cooler talk as protected. If your coworkers comment on it, agreeing and sharing their stories, it strengthens the argument that this is concerted activity. If your boss fires you for this post, claiming you damaged the company reputation, you may have a valid claim for reinstatement and back pay. However, a warning. This area of law swings like a pendulum depending on who is sitting on the board in Washington, D.C. The definitions of protected speech can tighten or loosen with different presidential administrations. Always err on the side of caution. If you must vent online, keep it strictly about working conditions, not personal attacks on people's character. So, how do you fight back using the NLRB? Unlike the EEOC, you do not need a right to sue letter to take action, but you also generally cannot sue strictly for NLRA violations in private court. The board is the court. You file a charge against employer. You can do this online at the NLRB website. It is free. You do not need a lawyer. The statute of limitations is 6 months. If you were fired for discussing your wages 7 months ago, you are generally out of luck. Once you file, an information officer will investigate. They will interview you and your witnesses. If they find merit to your charge, the regional director will issue a complaint against your employer. This is a powerful moment. It means the federal government is effectively taking your side. The remedy? The NLRB does not usually award massive punitive damages like a jury might in a discrimination case. You won't get millions for emotional distress. But they can order reinstatement, forcing the company to give you your job back. Back pay, paying you for the wages you lost while you were wrongfully fired. Notice posting, forcing the company to post a sign in the break room admitting they broke the law and promising not to do it again. Do not underestimate the satisfaction of seeing this sign. Now let's audit your employee handbook. If you have access to your handbook right now, look for these common illegal clauses. Employees are prohibited from discussing customer details or company business with anyone. Too broad, it could be interpreted to ban discussing wages. Be respectful at all times and do not post negative comments about the company online. Too broad, it could chill protected criticism of working conditions. Loitering in work areas while off-duty is prohibited. This might be illegal if it prevents off-duty employees from handing out union flyers in the parking lot. The NLRB recently adopted a new standard, as of 2023, the Stericycle decision, that makes it much harder for employers to maintain these vague, broad rules. If a reasonable employee could interpret a rule as banning them from organizing, the rule is likely presumptive unlawful. But what if your issue isn't about fighting with your boss? What if your issue is that you simply cannot work? What happens when the machinery of your life breaks down? What happens when you get cancer? What happens when your spouse is in a car accident and needs 24-hour care? What happens when you are pregnant and your doctor puts you on bed rest? In these moments, you don't need a union. You need time. And you need the guarantee that when the crisis passes, your job will still be there. Most Americans are terrified to take sick days for fear of being replaced. They drag themselves to work while ill, or leave dying relatives alone in hospitals, because they think the law offers them no shelter. They are wrong. There is a specific federal shield designed for the darkest medical moments of your life. It is complex, it is paperwork heavy, and it is strictly regulated, but it is the only thing standing between a health crisis and homelessness. In the next part, we are going to open the file on the Family and Medical Leave Act, FMLA. We will explain exactly who is eligible, and the 1,250 hours trap that disqualifies millions. We will discuss the Americans with Disabilities Act, ADA, and the magic words reasonable accommodation. We are going to show you how to force your employer to buy you the ergonomic chair you need, or give you the flexible schedule your health demands not as a favor but as a federal requirement. Your health is not a negotiation. This is part 6. We often operate under the delusion that our bodies are machines that will run indefinitely without maintenance. We prioritize deadlines over doctor's appointments. We answer emails from hospital beds. But the biological reality is that at some point, you, your spouse, or your parent will face a medical crisis that cannot be solved on a lunch break. When that happens, the tension between your physical survival and your economic survival becomes acute. This is where the Family and Medical Leave Act, or FMLA, enters the conversation. The FMLA is often misunderstood as a paid vacation program. Let's correct the record immediately. FMLA is unpaid. It is federal job protection, not wage replacement. Its sole purpose is to freeze your employment status in Carbonite for up to 12 work weeks in a 12-month period. It guarantees that when you return, you will be reinstated to your original job or an equivalent position with equivalent pay, benefits, and other terms of employment. But the FMLA is a fortress with very high walls, and millions of Americans are shocked to discover they are locked outside. Before you plan a surgery or prepare for the birth of a child, you must run the eligibility math. You must meet 3 strict criteria simultaneously. First, you must have worked for your employer for at least 12 months. These months do not need to be consecutive, but you must have that tenure. Second, and this is the trap for part-time workers, you must have worked at least 1,250 hours during the 12 months immediately preceding the start of your leave. That averages out to about 24 hours a week. If you worked 1,240 hours, you are not eligible. There is no rounding up in federal law. Third is the 50-75 rule. Your employer must have at least 50 employees within a 75-mile radius of your worksite. This rule exists to protect small businesses. If you work for a massive multinational corporation, but you are a remote worker living in rural Montana, and the nearest office is 100 miles away, you might technically be ineligible for FMLA, even if the company has 10,000 employees elsewhere. You must verify your status with HR specifically regarding this geographic stipulation. However, if you are eligible, the FMLA has a hidden superpower that most employees fail to utilize: intermittent leave. You do not have to take your 12 weeks all at once. If you have a chronic condition like migraines, Crohn's disease, or you are undergoing chemotherapy, you can use FMLA in increments as small as 1 hour, or the shortest increment of time the payroll system uses. You can use it to leave early for physical therapy every Tuesday. You can use it for unpredictable flare-ups. Let's look at a case study. Imagine Robert. Robert has severe asthma. During pollen season, he is occasionally late to work because of breathing treatments. His boss writes him up for tardiness. Eventually, he is fired. This is a classic FMLA violation if Robert had certified his condition. If Robert had gone to his doctor, filled out the Department of Labor's Certification of Healthcare Provider form, and submitted it to HR, those late arrivals would be protected as intermittent FMLA. The employer cannot count those absences against him for disciplinary action. By failing to certify the condition formally, Robert left himself exposed to the at-will firing. The lesson: if you have a chronic condition, get the FMLA paperwork on file before you need it. Do not wait for the crisis. But what if you don't need time off? What if you want to work, but your medical condition makes the standard environment impossible? What if you have developed severe back pain and can no longer sit in a cheap office chair for 8 hours? What if you have hearing loss and can't participate in conference calls without a transcript? This brings us to the Americans with Disabilities Act, ADA. Unlike the FMLA, the ADA applies to employers with just 15 or more employees, and there is no 1,250-hour work requirement. You are protected from day one. The core mechanism of the ADA is reasonable accommodation. This is a federal mandate that requires employers to modify the work environment to allow a qualified individual with a disability to perform the essential functions of the job, unless doing so would cause an undue hardship on the business. Here is where the magic words matter. If you tell your boss, "My back hurts, I need a new chair," that is a complaint. If you say, "I am requesting a reasonable accommodation under the ADA for my medical condition," you have just triggered a legal obligation. Once you say those words, the employer must engage in what the law calls the interactive process. This is a dialogue, a negotiation. They do not have to give you exactly what you want. If you ask for a $5,000 ergonomic chair, they can say, "No, that is an undue hardship, but we will provide this $500 ergonomic chair and a standing desk converter." As long as the alternative is effective, they have met their legal burden. Shutterstock. Let's analyze a scenario involving mental health, an area where ADA claims are skyrocketing. Imagine Elena. Elena works in a chaotic open-plan office. She has been diagnosed with PTSD and severe anxiety. The noise and constant interruptions trigger panic attacks, causing her performance to drop. Elena meets with HR. She brings a note from her psychiatrist. She requests permission to work from home 2 days a week and to wear noise-canceling headphones when in the office. The employer might push back. They might say, "Collaboration is essential, you must be here." However, under the interactive process, the employer must prove why being physically present 5 days a week is an essential function of the job. If Elena has been working remotely successfully during the pandemic, the employer's argument falls apart. Denying the headphones would be even harder for the employer to justify. Headphones cost nothing, if Elena provides them, and do not disrupt business operations. If they fire Elena for performance without ever addressing her accommodation request, they are walking into a discrimination lawsuit that is very difficult to defend. However, the ADA has limits. It is not a shield for misconduct. If you punch a customer or steal from the register, you cannot claim your disability made you do it and expect to keep your job. The ADA protects your ability to do the work. It does not absolve you of the consequences of violating conduct policies that apply to everyone. Furthermore, there is a dangerous intersection where FMLA and ADA meet. What happens when your 12 weeks of FMLA run out, but you still cannot return to work? Many employers will send you a termination letter on week 13. This is often a mistake on their part. Courts have held that a brief period of additional leave can be a reasonable accommodation under the ADA. If your doctor says she needs just 2 more weeks to recover, firing her immediately upon the expiration of FMLA could be an ADA violation. You must explicitly ask for this extension as an accommodation. Do not assume it is automatic. But let's be realists. Sometimes, despite the FMLA protections, despite the ADA accommodations, and despite your best efforts, the relationship ends. The company downsizes. The department is closed. Or they fire you for a fabricated reason that you don't have the energy to fight in court. You are now unemployed. Suddenly, your concern shifts from, "How do I keep my job?" to, "How do I eat?" There is a safety net designed for this moment, but it is one of the most bureaucratic and frustrating systems in the United States. Unemployment insurance, UI. And right next to it sits a document that looks like a lifeline but is often a trap: the severance agreement. Most people believe that if they are fired, they can't get unemployment. That is a myth. Most people believe that if they resign, they can't get unemployment. That is also sometimes a myth. And almost everyone believes that they should sign the severance agreement immediately to get the cash. In the next part, we are going to dissect the unemployment insurance system state by state. We will explain the concept of separation for cause versus layoffs, and how to win your UI appeal hearing if your boss tries to block your benefits. We will also perform a forensic analysis of a standard severance agreement. We will show you the clauses you must never sign, the rights you should never waive, and how to negotiate for more money when they are trying to push you out the door. The job is over, but the transaction is not. This is part 7. The moment you sit down for your termination meeting, 2 distinct timelines begin to run parallel to each other. The first is your emotional timeline: shock, anger, fear. The second is a rigid, bureaucratic timeline that will determine your financial survival for the next 6 months. Most people are too paralyzed by the first timeline to effectively navigate the second. They walk out of the building, go home, and stare at the wall. They wait a week to file for unemployment because they are embarrassed. They sign the severance agreement immediately because they are desperate for cash. These are tactical errors that can cost you thousands of dollars. Let's dismantle the unemployment insurance UI system first. This is not a charity. This is an insurance policy that your employer has paid premiums into on your behalf. You are not asking for a favor. You are making a claim against a policy. However, the insurance adjuster, the state unemployment office, operates on a specific definition of fault. The golden rule of UI eligibility is that you must be unemployed through no fault of your own. This is where the confusion destroys claims. Many workers believe that if they were fired, they are automatically ineligible. This is false. There is a massive legal canyon between fired for performance and fired for misconduct. Consider this case study. Michael. Michael is a graphic designer. His company pivots to a new software he struggles to learn. He tries his best, but he is slower than the other designers. He misses deadlines. His boss fires him for unsatisfactory performance. Michael assumes he cannot get unemployment because he was bad at his job. Michael is wrong. In the eyes of most state labor departments, Inability to perform a job despite genuine effort is not misconduct. It is simply a bad fit. Michael is likely eligible for full benefits. Now compare him to Steve. Steve works at the same company. Steve decides to leave work 2 hours early every Friday without telling anyone. He is warned twice in writing. He does it again. He is fired. This is willful misconduct. Steve deliberately violated a reasonable employer rule. Steve will likely be denied benefits. The battleground is often where the employer tries to frame Michael, performance, as Steve, misconduct, to prevent their unemployment tax rate from increasing. When you file your claim, be precise. Do not write, "I was fired." Write, "discharged for inability to meet performance metrics despite best efforts." If your claim is denied, do not accept it as final. You have the right to an appeal hearing. This is a mini-trial, usually conducted over the phone with an administrative law judge. Most workers are terrified of this. Do not be. The burden of proof is on the employer to prove misconduct. If they cannot produce the policy you violated, or proof that they warned you, or evidence that the rule was consistently enforced, you win. I have seen appeal hearings won simply because the employer didn't bother to show up. I have seen them won because the worker brought a notebook from part 2 of this series, showing that 3 other employees did the exact same thing and weren't fired. If you receive a denial letter, read the back. It will give you a deadline to appeal, often just 10 or 15 days. File the appeal. Now let's address the most dangerous document you will ever touch: the severance agreement. When an employer hands you a severance agreement, they are not giving you a parting gift. They are buying something from you. Specifically, they are buying your general release of claims. If you read the fine print, you will see a terrifying block of text in all capital letters. It lists every major employment law in existence, Title VII, the ADA, the ADEA, the FMLA, and says that by signing this, you agree to never sue them for any violation of these laws that occurred in the past. You are selling your right to justice for a few weeks of pay. Sometimes this is a fair trade. If you have no intention of suing and just want to move on, taking the money makes sense. But you must know what you are signing. If you are over 40 years old, federal law steps in to protect you. Under the Older Workers Benefit Protection Act, OWBPA, your employer must give you at least 21 days to consider a severance offer. If they say, "You have to sign this by 5 p.m. today," they are violating federal law. Furthermore, after you sign, you have a 7-day revocation period, where you can change your mind, cancel the deal, and give the money back. For everyone else under 40, there is no federal 21-day rule, but coercion can still void a contract. If they physically bar the door and refuse to let you leave until you sign, that contract is worthless. Let's look at the non-disparagement clause. This is standard boilerplate. It usually says, employee agrees not to make any negative statements, written or oral, about the company, its officers, or its products. For years, this was ironclad. But the landscape is shifting beneath our feet. In a landmark decision, McLaren-McComb 2023, the National Labor Relations Board, NLRB, ruled that overly broad non-disparagement clauses in severance agreements for non-supervisory employees can violate the National Labor Relations Act. Why? Because if you can't disparage the company, you can't tell your former coworkers about the illegal working conditions you faced. You can't participate in an NLRB investigation. The board found that silencing workers in this way interferes with their Section 7 rights. Does this mean you can sign it, take the money, and then trash them on Twitter? Proceed with extreme caution. This is a developing area of law, and if you are a supervisor, as defined by the NLRA, you generally do not have these protections. Always assume the contract is enforceable until a lawyer tells you otherwise. Here is the secret. Severance is negotiable. HR expects you to negotiate. They have a budget. If they offer you 4 weeks, they likely have authorization for 6 or 8. How do you negotiate when you have no job? You use leverage. Leverage point 1, the waiver. If you have a legitimate, documented suspicion of discrimination or wage theft, you can politely suggest that your legal counsel needs to review the claims you are waiving. Given the unresolved issues regarding my unpaid overtime, I'm not comfortable signing this release for only 4 weeks of pay. However, I would be willing to resolve all outstanding matters for 12 weeks. You are effectively offering to settle a potential lawsuit before it happens. Leverage point 2, non-monetary terms. Sometimes the company is broke. They truly cannot pay more cash. In that case, negotiate for things that cost them nothing but are valuable to you. The neutral reference clause. Force them to agree that if a future employer calls, they will only confirm your dates of employment and job title. They will not say you were fired. They will simply say employment ended. This can save your career. The non-compete waiver. If you have a non-compete agreement that stops you from working in the industry, ask them to waive it as part of the severance package. Keeping company property. Ask to keep your laptop or phone after they wipe the data. But as you navigate the severance negotiation and the unemployment queue, there is a looming predator that attacks almost everyone who leaves a job in America. It is the sudden catastrophic loss of health insurance. You might think, I'm fine, I have COBRA. Or you might think, I'll just get Obamacare. But then you open the envelope and see the price tag. You realize that your employer was paying 80% of your premium, and now you have to pay 102% of it. You are looking at a bill for $1,800 a month when you have zero income coming in. Or worse, you decide to risk it and go without insurance for a month, only to trip on a curb and break your ankle, incurring a $40,000 emergency room bill that bankrupts you before you even find your next job. The gap between employment is the most dangerous time for your physical and financial health. In the next part, we are going to navigate the healthcare minefield. We will explain the qualifying life event window. We will do the math on COBRA versus the Affordable Care Act marketplace. We will explain how to retroactively activate COBRA if you have a medical emergency during the election period, essentially getting free insurance coverage for a wait-and-see period. Do not get sick until you watch the next video. This is part 8. You open the envelope. It says COBRA continuation coverage. You see a number that makes your stomach drop. For the last few years, you thought your health insurance cost $150 a month because that was the deduction on your pay stub. You are now staring at a bill for $1,800 a month. Welcome to the cold water shock of the American healthcare system. The reason that number is so high is that for the duration of your employment, your company was likely subsidizing 70% to 80% of the premium. Now that you are terminated, that subsidy has evaporated. Under the Consolidated Omnibus Budget Reconciliation Act, COBRA, you have the federal right to keep your exact same insurance plan for up to 18 months, but you must pay the entire premium yourself, plus a 2% administrative fee. For a family of 4, COBRA premiums can easily exceed the cost of a mortgage. But before you throw that letter in the trash and decide to live dangerously without insurance, you need to understand the single most valuable loophole in the termination process: the COBRA election period. COBRA is unique because it is retroactive. By law, you have a minimum of 60 days from the date you receive your notice, or the date your coverage ends, whichever is later, to decide whether or not you want the coverage. Here is the strategic implication. This 60-day window acts as a free safety net, provided you have the savings to pay the premium if necessary. Let's play out a scenario. Imagine Jennifer. She is laid off on March 1st. Her company insurance ends on March 31st. She receives her COBRA paperwork on April 5th. She has until roughly June 4th to decide. During April and May, Jennifer does not pay the COBRA premium. She holds on to the check. She is technically uninsured, but she has a time machine in her pocket. Scenario A. On May 20th, Jennifer breaks her leg. The hospital bill is $50,000. She immediately fills out the COBRA paperwork, writes the check for the April and May premiums, let's say $3,600 total, and sends it in. Because COBRA is retroactive, her insurance is reinstated back to April 1st. The insurance company must cover the broken leg, as if she never had a gap in coverage. She paid $3,600 to save $50,000. Scenario B. Jennifer stays healthy. On June 1st, she starts a new job with new benefits. She never sends the COBRA check. She shreds the paperwork. She just got 2 months of coverage for free, because the option to buy it was all she needed to mitigate the risk of catastrophe. This strategy is known as floating COBRA. It is dangerous if you are disorganized. If you miss the 60-day deadline by even 1 hour, the option vanishes, and you are liable for any medical bills you incurred. But if you are disciplined, it is a powerful tool to bridge the gap between jobs without draining your savings. However, if you know you will be unemployed for longer than 60 days, or if you have chronic conditions that require expensive prescriptions now, floating isn't an option. You need active coverage, and paying 102% of your premium is likely unsustainable. This brings us to the Affordable Care Act (ACA) marketplace, commonly known as Obamacare. Losing your job-based health insurance is a qualifying life event. This is a golden ticket. It allows you to shop on healthcare.gov outside of the standard end-of-year open enrollment period. Crucially, you have a 60-day window from the loss of your coverage to enroll in a marketplace plan. The advantage here is strictly financial. Marketplace plans are often eligible for premium tax credits, subsidies, based on your income. If you are unemployed, your income for the year might be significantly lower than usual, which could qualify you for a plan that costs $100 or $200 a month, rather than the $1,800 COBRA plan. But here is the income trap that catches thousands of unemployed workers. When applying for subsidies, the government asks for your estimated annual household income for the current year. If you estimate too high, you get no help. If you estimate too low, specifically below the federal poverty level, you might not qualify for subsidies at all. Instead, in many states, you will be pushed into Medicaid. While Medicaid is free, the network of doctors who accept it is often much smaller than private insurance. If you need to keep your specific oncologist or therapist, you must check if they accept Medicaid or the specific marketplace plan you are buying. Do not assume your doctor takes Blue Cross generally. You need to know if they take the specific Blue Cross HMO Silver Pathway plan you are buying. The devil is in the network details. Let's look at a case study of a double whammy failure. Imagine Mark. Mark loses his job. He ignores the COBRA letter because it is too expensive. He thinks, I'll just sign up for Obamacare later if I don't find a job. He waits 3 months. He finds nothing. He decides to go to healthcare.gov. He is blocked. Why? Because the qualifying life event window is only 60 days. Mark missed the COBRA deadline 60 days. He missed the ACA special enrollment deadline 60 days. Mark is now locked out of the health insurance market entirely until the next open enrollment period in November, with coverage starting in January. If Mark gets cancer in August, he is financially ruined. Do not be Mark. The moment you are terminated, put a recurring alert in your phone for day 45. By day 45, you must have either found a new job, purchased a marketplace plan, or prepared to send that COBRA check. So, you have secured your physical survival. You have food on the table via unemployment insurance. You have health coverage via the marketplace or the COBRA bridge. You have your documentation journal from Part 2. You have your right to sue letter from the EEOC, Part 3, or your audit records from the Department of Labor, Part 4. Now, you are ready to go on the offensive. You want justice. You want the company to pay for what they did. You want to sue. But the legal system is a marketplace, not a charity. And the currency of that marketplace is the billable hour. Most employment lawyers charge between $300 and $800 an hour. If you are unemployed, you cannot afford this. This leads you to the concept of the contingency fee. You see billboards for lawyers saying, "No fee unless we win." Sounds perfect, but it is one of the most complex, opaque, and predatory relationships in the professional world if you do not understand the math. A contingency fee means the lawyer takes a percentage of your final settlement or verdict, usually 33% to 40%. That sounds fair. But does that 40% come out before or after taxes? The answer will shock you and affects your IRS bill. Does it come out before or after costs, the filing fees, the deposition transcripts, the expert witnesses? Costs can run into the tens of thousands of dollars. And most importantly, how do you even get a lawyer to take your case on contingency? Lawyers are risk investors. They are venture capitalists of litigation. They reject 95% of the potential clients who call them. They are not looking for fairness. They are looking for damages. If you were wrongfully terminated, but you found a new job 2 weeks later that pays more money, your economic damages are effectively zero. Even if the company was evil, even if they broke the law, a lawyer might refuse your case because there is no pot of gold at the end of the rainbow for them to take 40% of. In the final part of this masterclass, we are going to walk into the law firm. We are going to teach you how to pitch your case to a shark. We will explain the difference between a settlement mill and a litigator. We will reveal the tax bomb hidden in discrimination settlements that the IRS rarely talks about. And finally, we will discuss the emotional cost of litigation, the years of your life you trade for a check, and how to decide if the fight is truly worth it. You have the map. Now we have to decide if you want to climb the mountain. This is part 9. This is the room where reality sets in. You are sitting across from a lawyer in a high-rise office, or perhaps a cramped, messy room in a strip mall. You are telling your story. You are crying. You are explaining how unfair it was, how they humiliated you, how they ruined your career. You expect the lawyer to be outraged. You expect them to slam their fist on the table and promise to fight for justice. Instead, they look at you and ask a cold mathematical question. How much money have you lost, and how quickly did you find a new job? This is the moment you learn that the legal system is not about feelings. It is about economics. Lawyers who work on contingency fees, taking 33% to 40% of the winnings, are investors. They are analyzing your case the way a venture capitalist analyzes a startup. They are looking for return on investment. To get a shark to bite, you need to understand economic damages. If your employer fired you illegally because of your race, but you are a superstar who found a higher-paying job 2 weeks later, your economic damages are effectively zero. You lost 2 weeks of pay. If you sue, the jury might award you that 2 weeks of pay. A lawyer will look at that and say, 33% of 2 weeks' pay does not cover my light bill. I cannot take this case. This is the cruel paradox of employment law. The more employable and resilient you are, the less attractive your case often is to a contingency lawyer. Conversely, if you have been unemployed for 2 years, the potential damages are high, but the lawyer will then ask, why haven't you found a job? Did you try? This introduces the legal doctrine of mitigation of damages. You have a legal duty to try to fix the problem your former employer caused. You cannot simply sit on your couch, watch Netflix for a year, and expect the company to pay your full salary for that year. You must prove you were actively applying for jobs. If the company's lawyers can prove that there were jobs available that you didn't apply for, or that you turned down a reasonable offer, they can cut off your damages. So, when you pitch your case to a lawyer, do not just bring your sob story. Bring your data. Bring the journal we discussed in Part 2. Bring the right to sue letter from Part 3. Bring a spreadsheet of your lost wages. And bring a log of every job you have applied for since the termination. Show them you are a professional plaintiff who has done the homework. This signals that you will be a good witness, calm, organized, and credible. But you must also vet the lawyer. Not all law firms are created equal. You need to distinguish between a settlement mill and a litigator. A settlement mill operates on volume. They take hundreds of cases. They file a demand letter. They take whatever lowball offer the company gives, say $5,000 or $10,000, and they move on. They never go to court. They never take depositions. If the company fights back, they drop you. A litigator is different. They take fewer cases, but they prepare every single one as if it is going to trial. Companies know who these lawyers are. When a true litigator files a complaint, the settlement offer is often double or triple what a mill gets, because the company knows the threat is real. Ask the lawyer directly, how many employment cases have you taken to trial in the last 5 years? If the answer is 0, walk away. You want the lawyer who is willing to go the distance, even if you hope to settle early. Let's assume you find the right lawyer. You file the lawsuit. Now begins the discovery phase. This is the part that movies rarely show. It is invasive, brutal, and exhausting. The company's lawyers are allowed to investigate your life to attack your credibility. They will subpoena your medical records. They will demand your text messages. They will scroll through 10 years of your social media. If you claimed emotional distress, they will ask to interview your therapist. They will try to prove that your stress isn't from the firing, but from your divorce or your childhood or your financial habits. They will try to humiliate you into dropping the case. Then comes the deposition. You will sit in a conference room for 8 hours while opposing counsel grills you. They will twist your words. They will ask the same question 10 different ways to catch you in a lie. If you lose your temper, you lose the case. This process can take a year. Sometimes 2. And if you win, if you survive the summary judgment motions, the settlement conferences, and the trial, and the jury awards you $100,000, now you face the final boss, the Internal Revenue Service. There is a massive misconception that legal settlements are tax-free. Generally, the only settlements that are tax-free are those for physical injury or physical sickness. If you are hit by a falling crate at work, a workers' comp or personal injury issue, that money is usually tax-free. But if you are suing for lost wages, discrimination, or emotional distress, that money is generally taxable. The IRS views lost wages as, well, wages. You owe income tax on them. Even worse, you are often taxed on the entire amount, including the portion that goes to your lawyer. Imagine you win $100,000. Your lawyer takes $40,000. You take $60,000. In the past, you might have been taxed on the full $100,000, putting you in a higher tax bracket, meaning you could end up paying taxes on money you never touched. While the Civil Rights Tax Relief Act has helped fix this double taxation for specific discrimination cases, allowing an above-the-line deduction for attorney fees, it is complex and state laws vary. You could still face a tax bill of $20,000 or $30,000 on that settlement. Always consult a CPA before signing the final check. So, is it worth it? Is it worth the years of stress, the invasion of privacy, the risk of losing, and the tax bill just to hold them accountable? For some, the answer is no. Moving on, finding a better job, and living well is the best revenge. There is no shame in walking away to protect your peace. But for others, the answer is an absolute yes. Because when you fight back, you change the calculation for the company. You make it expensive for them to discriminate. You make it risky for them to steal wages. You are not just fighting for your own paycheck. You are fighting for the person they would have hired next. You are forcing the system to self-correct. We have covered a massive amount of ground in this series. We started with the disclaimer, understanding that the law is a living, breathing, dangerous animal. We built a paper trail, part 2. Because documentation is the shield that protects your career. We navigated the EEOC, part 3, to fight discrimination. We audited our paychecks with the Department of Labor, part 4, to reclaim stolen wages. We stood our ground on safety with OSHA, part 5. We broke the silence on salary discussions with the NLRB, part 6. We protected our health with the FMLA and ADA, part 7. We secured our survival with unemployment and severance negotiations, part 8. We bridged the healthcare gap with COBRA and the ACA, part 9. And today we looked the legal system in the eye. You now possess a toolkit that 99% of the workforce does not have. You know that human resources works for the company, but federal agencies work for the law. You know that your signature is valuable currency. You know that silence is the enemy of justice. The American workplace is designed to make you feel small. It is designed to make you feel powerless. But as we have seen over these 10 episodes, you are not powerless. You are a citizen with rights codified in federal statutes. You have levers you can pull. You have doors you can knock on. The next time you walk into that office, keep your head up. Keep your journal open. And never ever be afraid to read the fine print. This has been Navigating Workplace Issues, a guide to U.S. resources. Thank you for watching.